I was drunk. I didn't know what I was doing. You've heard it a million times, right? In movies, on TV shows. But does that argument actually hold up in a real court? Can you commit a serious crime, blame it on being drunk, and just walk free? Okay, let's really get into it.
To really get our heads around how this defense works or doesn't work, we have to look at a landmark case, one that pretty much set the rules. And it all kicks off on one seriously chaotic night.
So, picture this. It's a house party in California. It's late, like 2 in the morning late. And yeah, the alcohol has been flowing for hours. And then things go south, fast. An argument boils over into a full-blown physical fight. There's screaming, total chaos, and someone calls the cops. But when the officers show up, the situation just explodes. A struggle breaks out, and in the middle of it all, an officer's gun is grabbed. Then, shots are fired. An officer is on the ground, wounded. And this is where we meet David Hood, in a case called People v. Hood. Now, the facts of what happened, well, they were pretty brutal, and nobody was really arguing about them. After drinking a lot, Hood forced his way into his ex-girlfriend's house and assaulted her. When the police got there, a fight broke out, and during that fight, Hood got his hands on Officer Alfred Elia's gun and shot him, once in each leg. So what Hood did was crystal clear, but his defense? That was a whole other story. He argued he was just too drunk to be held fully responsible. This case really cuts to the absolute heart of criminal law. You see, to convict someone of a crime, the prosecution almost always has to prove two completely separate things. There was zero question that David Hood did the physical act of shooting the officer. But the entire case hinged on a totally different question. What was going on inside his head at that exact moment? Did he have what the law calls a guilty mind? In legal speak, this is the classic battle between actus reus, which is the guilty act, and mens rea, the guilty mind. And you really need both for a conviction to stick. So pulling a trigger, that's the actus reus. Proving you intended to do it and what would happen, that's the mens rea. And this is where it gets so tricky. A legal review from DePaul University put it perfectly, saying the law is buffeted between two conflicting principles. I mean, think about it. On one hand, we have this deep-down feeling that a bad act deserves punishment. But on the other hand, our entire justice system is built on the idea that a true crime requires a guilty mind. So, how in the world does the law solve this problem? Well, let's zoom in on the specific rule that was at the center of the Hood case, California Penal Code 29.4. And believe me, this is where the details are everything. The law sets up this fascinating two-part test. First, the general rule is super clear. Choosing to get drunk is not an excuse for a crime. A defendant can't say, "I was so wasted, I lacked the capacity to form intent." But, and this is a huge but, here's the exception. Evidence of being drunk can be used to argue that the defendant didn't actually form the specific intent needed for certain crimes. Now, that difference is subtle, but it is absolutely critical. The law isn't asking, were you so drunk you couldn't have formed the intent? Instead, it's asking a much finer question. In that exact moment, did you actually form the precise mental state that this particular crime requires? And this right here leads us to the most important piece of the puzzle. The success of this entire defense comes down to the type of crime you're charged with. The law basically splits crimes into two big buckets, all based on the kind of intent required. First, you've got your general intent crimes. For these, it's pretty simple. The prosecution just has to prove you intended to do the physical act itself. That's it. Think about battery. The only intent needed is the intent to do the violent act of hitting someone. But then you have specific intent crimes, and these require an extra layer of thinking. Here, the defendant has to have an intent to do some other act or achieve an additional goal beyond just the physical action. It's not just about the act, it's about the purpose behind it. And this chart just lays out the difference perfectly. A general intent crime like battery is pretty straightforward, but then look at a specific intent crime like burglary. It's not enough to prove you intended to go into a house. The prosecution has to prove you went in with a specific intent to steal something once you were inside. That extra goal is what makes intoxication a potentially relevant factor. So let's circle all the way back to David Hood. How did the California Supreme Court take this whole framework and apply it to what he did on that awful night? Okay, remember, Hood was facing two major charges. The first one, and the most serious, was assault with intent to murder. The key phrase is right there in the name, with intent to murder. Those words automatically make this a specific intent crime. It meant the prosecutors had to prove not just that Hood shot the officer, but that at the very moment he pulled the trigger, he had the specific, deliberate goal of ending that officer's life. And because of that, the court ruled that evidence of Hood's extreme drunkenness was totally relevant. A jury had to consider whether he was so impaired that he didn't and couldn't actually form that specific intent to kill, even if he did intend to pull the trigger. But then, of course, there was the second charge, assault with a deadly weapon. And on this one, the legal logic completely flips on its head. The court decided that simple assault with a deadly weapon is a general intent crime. It only requires the intent to do the violent act itself, in this case, firing the gun. It doesn't require any further intent, like wanting to injure or kill. And because it's a general intent crime, the court made its landmark decision. Hood's intoxication was not a defense. It was irrelevant. As long as he intended to commit the violent act, his drunkenness could not excuse it. Period. So what's the big takeaway from all this? Why does this really technical-sounding legal distinction have such massive consequences in the real world? Well, first and foremost, this is not a get-out-of-jail-free card. The intoxication defense isn't about excusing terrible behavior. It's about upholding a fundamental principle of our justice system. The prosecution has to prove every single element of the crime, and that includes the defendant's specific state of mind. And trying to use this defense is incredibly difficult. An attorney can't just stand up and say, "My client was drunk." They have to present cold, hard evidence. We're talking blood alcohol tests, eyewitnesses describing how impaired the person was, video footage, even expert testimony on how that level of intoxication affects the brain's ability to form complex goals. Which leaves us with a final, really tough question. The law tries to draw this clean line between someone who acts rashly because they're drunk and someone whose mind is so impaired they can't form a specific intent. But in the blur of a real-world crime, how clear is that line really? If a person voluntarily gives up their own judgment, where does their legal responsibility truly begin?